I have agreed with my colleague, the Minister for Environment, Community and Local Government, Deputy Phil Hogan, that houses demonstrated to be subject to a certifiable level of pyrite heave should receive an exemption from local property tax. The exemption may be claimed for 3 consecutive liability dates. The Minister for the Environment, Community and Local Government will provide regulations stipulating how residential properties should be tested for pyrite-induced damage. These regulations will also provide for the issue of a certificate in respect of a property that has been verified as having a level of damage significant enough to warrant exemption. Like my colleagues in government, I am conscious of the difficulty some homeowners are experiencing in meeting their mortgage obligations. Under proposed new amendments, a person who has entered into an insolvency arrangement, that is, a debt settlement arrangement, or a personal insolvency arrangement under the Personal Insolvency Act 2012, may qualify for a deferral of the local property tax that falls due for the payment by that person during the period for which the insolvency arrangement is in effect, where a valid claim is made to the Revenue Commissioners. Further proposed new measures provide for the possibility of a deferral for liable persons who cannot, without excessive hardship, pay local property tax when it becomes payable as a consequence of a significant unexpected financial loss or expense. This particular deferral will operate on a different basis to deferral arrangements provided for in the original Act. A liable person must apply in writing to the Revenue Commissioners for the deferral and meet the criteria that will be set out in guidelines to be published by the Revenue Commissioners. Deferral cannot commence until the Revenue Commissioners have received from the liable person whatever information or documentation they require to make a decision, and having made their decision, notify the liable person that a deferral is allowed, subject to whatever conditions they may impose, in accordance with the guidelines that they will publish. The bill also allows for a reduction in the chargeable value of a relevant residential property that has been adapted for occupation by a disabled person, where the adaptation has been grant-aided by a local authority. The reduction is limited to the lesser of the chargeable value attributed to the adaptation work carried out on the property and the maximum grant payable under the relevant local authority scheme. The relief will not apply after the sale or transfer of the property unless the person with a disability continues to reside in the property. The bill also provides for an exemption for a residential property that is purchased or adapted for use as a sole or main residence by an incapacitated individual, where an award has been made by the Personal Injuries Assessment Board or a court, or where a trust has been established specifically for the benefit of permanently and totally incapacitated individuals. To be exempt from payment of local property tax, a residential property must be acquired or adapted to make it suitable for occupation by an incapacitated individual. To avail of the exemption, in cases of adaptations, the adaptation cost must be greater than 25% of the chargeable value of the property before such work took place. The exemption will no longer apply if property is sold and the incapacitated individual no longer occupies it as his or her sole or main residence. The bill also allows a personal representative of a deceased liable person, where that person was the sole liable person in relation to a residential property, to qualify for a deferral on making the required valid claim. The deferral may be claimed in respect of local property tax that was due and unpaid at the time of the liable person's death. Local property tax that was deferred by the deceased liable person. The local property tax that falls due in the 3-year period immediately following death. The bill limits the period of time for which personal representatives may qualify for a deferral to 3 years commencing from the date of the death. However, if the personal representatives are in a position to transfer the property to a beneficiary or to distribute the sales proceeds where the property has to be sold, the period of deferral ends at that point. In all cases, the personal representatives will be responsible for payment of the deferred local property tax when the period of deferral comes to an end. I previously indicated that properties used for accommodation purposes by groups such as the Girl Guides will receive an exemption from local property tax. This was on foot of a commitment I gave during the Senate debate on the Finance Local Property Tax Act 2012. The bill now provides for an exemption for residential properties used by a charitable body for recreational activities connected with a charitable purpose, where this is not done on a commercial basis. The chargeable value of all properties for which the liable person is a local authority or an approved housing body will be deemed to be within the first valuation band for the first valuation period, that is up to the 31st of October 2016. Local authorities and approved housing bodies may also defer their 2013 local property tax liability until 2014. This is to allow such bodies to put in place arrangements for the payment of the tax and for the valuation of their properties. An amendment that is proposed to deal with issues arising where there is a change of liable person between valuation dates has been the focus of much media and opposition attention in recent weeks. Where the liable person changes between valuation dates, the vendor will be obliged to provide the purchaser with details of the chargeable value that was established on the first valuation date, along with any relevant documentation. Failure to comply may result in a fine of €500 being imposed on the seller of the property. The new owner is obliged to submit a revised return and chargeable value for the next liability date, where it appears to him or her that the chargeable value declared by the previous liable person was too low, given the circumstances that would have prevailed at the time that chargeable value was established. These amendments are intended to act as a deterrent against under-declaration of the chargeable value of a relevant residential property by a liable person who intends selling the property before the next valuation date. Contrary to media coverage and opposition commentary, the new provision offers a level of protection to purchasers. In the absence of this amendment, the deliberate and serious under-declaration of a property's value will be binding on a new owner or liable person where a property is sold for the next valuation date.